What is legal capacity to marry for annulment? Imagine entering a marriage thinking everything is perfect, only to find out later that it might not be legally valid. That's where understanding legal capacity to marry becomes important. When a marriage is challenged for annulment, the court looks at whether both people had the ability to give valid consent at the time of marriage. This ability is called legal capacity. It means that both parties must meet certain rules and requirements set by law to make their marriage valid. If one person lacked this capacity, the marriage could be declared null and void. One key factor is age. Every place has a minimum age to marry, usually 18. If someone was younger than that and did not have proper approval from a parent, guardian, or court, the marriage can be annulled. Usually, the annulment must be filed while the underage person is still a minor or shortly after reaching adulthood. Mental capacity is another important point. A person must understand what marriage means and be able to make a clear decision. If someone was mentally incapacitated because of illness, developmental disability, or intoxication at the time of marriage, they might lack legal capacity. This incapacity must exist during the marriage ceremony itself. If it develops later, annulment is not possible, but divorce might be an option. Consent must also be given freely. If someone was forced, threatened, or tricked into marrying, like through fraud or lying about important facts, their ability to consent was compromised. This can be grounds for annulment because the marriage was not entered into voluntarily. Physical capacity can matter too. In some places, if a person cannot engage in sexual intercourse due to physical issues that are incurable and unknown to the other spouse at the time, that could be a reason to annul the marriage. Prohibited relationships are also a part of legal capacity. Marriages between close relatives or when one person is already married to someone else are not allowed. These marriages are considered invalid from the start. When someone challenges a marriage based on lack of legal capacity, they need to show evidence that at the time of marriage, one of these conditions was not met. The court then decides if the marriage is void or voidable. Void marriages are invalid from the beginning and do not need any action to be declared invalid. Voidable marriages are valid until a court orders an annulment. In family law, proving lack of legal capacity is essential because it protects individuals who were not able to give proper consent. Annulments treat these marriages as if they never happened, and like divorce, which ends a valid marriage. So, in simple terms, legal capacity to marry for annulment means both people had the legal ability and freedom to marry at the time. If age, mental state, coercion, fraud, physical issues, or prohibited relationships were involved, the marriage might be annulled. This process helps ensure that only marriages entered into with proper consent and capacity are recognized as valid.